This year marks the 160th anniversary of the Congress's enactment of the False Claims Act. Signed into law by President Lincoln in 1863, the False Claims Act is the government's most powerful tool in fighting and deterring fraud. As we all know, the key to the success of False Claims Act is that it allows whistleblowers to stand in the shoes of the federal government and then sue fraudsters. Since passage of the amendments that I offered in 1986, the False Claims Act has recovered more than $72 billion for the taxpayers. It saved untold billions because it deters fraudsters from cheating the system in the first place. In 2022, the Justice Department reported that they recovered more than $2 billion from False Claims Act cases. Despite the enormous success of the False Claims Act, I know it's hard to understand, but it's constantly under attack by activist judges and defendants who seek to rewrite the text of the statute to achieve some of their own policy goals. That's why I strongly advocated for the Supreme Court to take up the super value case. In that case, the lower courts stated that subjective intent to defraud the government didn't matter so long as there was a reasonable ambiguity in a statute or a regulation. I know it's hard to understand, but in other words, if you defraud the government and you intended to defraud the government, the court said that you can still avoid liability if your attorneys can show that there was some ambiguity in the rule or statute that you breached. Such an absurd reading is a complete departure from both the text of the False Claims Act and over 100 years of common law fraud precedent. It also ignores the importance of subjective intent, which every first-year law student is taught. The lower court's radical departure from the statute continues an unfortunate tradition of some courts interpreting the False Claims Act in an unduly restrictive fashion, which Congress and the Supreme Court have repeatedly stepped in to correct. I'm glad to hear that the Supreme Court has accepted writ for this important case and remain hopeful that they'll set the record straight. Lastly, and most importantly, I want to leave you with this. The False Claims Act is the most powerful tool the government has to combat fraud. But it's the brave whistleblowers, let me emphasize, the brave whistleblowers who make the law successful. Whistleblowers are the government's eyes and ears in uncovering and deterring fraud. Without you whistleblowers, the False Claims Act would simply not work. So I'd like to thank you for inviting me to speak today and for your continued support of the False Claims Act, and most importantly, for those whistleblowers across our country.
Senator, thank you for your time today. We're here to discuss your favorite topic, the False Claims Act. As a longtime champion of the law, I'd like to ask you a few questions relating to it. What amendments to the False Claims Act are being considered?
Well, last Congress, my amendment to strengthen the False Claims Act was actually passed out of Judiciary Committee. The title of the bill is the False Claims Amendment Act of 2021. Unfortunately, as happens so many times, leadership didn't schedule a vote on this very important piece of legislation. So like you have to do after every Congress has ended and your bill hasn't passed, it's reintroduced. So I'm going to reintroduce it. I'm going to continue to work in this new Congress to ensure the passage of this legislation.
Both before and after you introduce legislation, such as a False Claims Act amendment, from whom do you seek advice on statutory language? Everyone at this conference has some tweaks they'd love to make, I'm guessing. How can they engage you and your staff? Via organizations? From whom do you want to hear?
Well, first of all, don't be bashful, because any time that I introduce legislation on this or any other bill, I seek advice from all sorts of differing viewpoints. For example, when I introduced the False Claims Amendment Act last Congress, my staff spoke with the Department of Justice, plaintiffs' attorneys, defense attorneys, and representatives from the pharmaceutical industry, the hospital associations, and the U.S. Chamber of Commerce, just to name a few. And if we hadn't sought those stakeholders out, they probably would have come to us anyway. But I think it's my responsibility to get as much information as I can before I introduce. So, as a result, no stakeholder group who sought an audience with my staff was turned down or will be turned down.
One of the things the Supreme Court is supposed to do is to interpret the law based, in part, on congressional intent. In False Claims Act cases, you speak with unique authority in this regard. When you've taken the time to explain to the court the intent of the False Claims Act amendments that you've written, how seriously should they weigh your point of view, do you think? And how maddening is it if they interpret the law contrary to your own intent as the author, as was arguably the case in Escobar?
Well, of course, every senator wants the courts to just look at every word we say about a bill. But, you know, congressional intent is very important. But we first of all know the courts have a very high responsibility to focus first and foremost on the text of the statute. In many instances, they don't do that. So the super value case that you've heard me talk about, that I highlighted in my opening statement, is a perfect example of activist judges performing mental gymnastics to interpret text how they was hoping to read in the first place. In instances where the statutory text is crystal clear, such as this, one can argue that congressional intent is well understood. I often speak out on bad case law because I believe the courts aren't following the text of the statute. In other instances where the text is perhaps not as clear as I would have liked, I'll speak out to explain the intent behind the text. So as the author of the 1986 amendments, I believe I'm uniquely positioned to provide insight into the intent behind the law.
Some of the defense lawyers listening today believe that the damages and penalties in the False Claims Act are so overpowered that their clients simply can't risk a jury trial, even if that means agreeing to a settlement in a case where they sincerely believe there was no wrongdoing. Do you worry about the possibility of that sort of injustice?
Now, you know, these are favorable and very pertinent arguments that I hear all the time. But I've been hearing these arguments for a long time, dating back to even the original 1986 amendments. The truth that defense lawyers don't want to tell you is that many companies factor in fines and judgments against them as part of the cost of doing business. If a fine or a penalty is too low, a company will calculate how often they're likely to get caught and how much the fine will be. If they're able to turn a profit larger than the expected fines, they're most likely to defraud the government. The purpose of the False Claims Act is both to recover money lost to fraud and to deter fraud at the same time. The penalties of the False Claims Act serve to deter fraud, and there's not one person who can say with a straight face that it hasn't worked to deter fraud.
Finally, can you reflect for just a minute on your personal responsibility for a law that have returned literally tens of billions to the U.S. government? By any standard, that's a lot of money. How does it rank with your other legislative achievements?
Well, during my first term in the United States Senate, I sunk my teeth into wasteful spending in the Pentagon And that's why these amendments to the False Claims Act, particularly Qui Tam, were passed in 1986. We made a big case for the need for this legislation. My updates empowered whistleblowers to bring lawsuits against alleged fraudsters on behalf of the federal government. And then those whistleblowers share in a percentage of the recoveries collected on behalf of the American people. Getting this law passed was very, very difficult. Fraud is big business, especially when you have a federal government that's spending hundreds of billions of dollars a year with little to no oversight. I faced a lot of resistance in the 1986 amendments, mostly from defense contractors who were raking in billions defrauding the government. Now it isn't so much the defense industry today, as it seems like more of the whistleblower complaints come from the healthcare industry. I have to be proud of my work to champion protections for whistleblowers who risk their livelihoods and their reputations for just telling the truth. Although my whistleblower updates took aim at the Pentagon price gougers, fleecing taxpayers, and compromising military readiness and troop safety, my Qui Tam provisions have become the government's #1 tool against all types of fraud. To this very day, my amendments to the False Claims Act have helped recover more than $72 billion and at the same time saved untold billions more by just simply discouraging fraudsters from cheating the system in the first place.
Thank you.